order. Thank you, everybody. As most of us know, unfortunately, it is very likely we will be interrupted by votes, likely around 5:45. I thank the witnesses for being so flexible to keep your introductions to 8 minutes each, which means that if we are interrupted, at least we won't be interrupting you midway through your remarks. Bienvenue tout le monde. Merci beaucoup pour.
Welcome, everyone, and thank you for your testimony.
Have today, for the first panel, from the National Association of Women and the Law, we have Julie Sugarman, who is a consulting director, and Anne Levesque, the co-chair of the National Steering Committee. And from the New Brunswick Coalition for Pay Equity, we have Joanne Perrin, the executive director. And we will start with the Association for Women and the Law. Is it Julie or Anne who plans to speak? Okay, so Julie, you go ahead.
My colleague Anne Levesque and I are pleased to be appearing before you on behalf of the National Association of Women in the Law. NAL is a national non-profit feminist organization that has worked since 1974 to promote the substantive equality rights of Canadian women through legal education, research, and law reform advocacy. NAL developed significant expertise in pay equity and has worked collaboratively with federal unions and other women's equality rights organizations to provide evidence to the Standing Committee on the Status of Women multiple times, as well as to the Bilson Task Force on Pay Equity. We have, on numerous occasions over the last 30 years, presented on the problems with the complaint-based model under the Canadian Human Rights Act and the importance of proactive legislation at the federal level. For ease of reference, NAL will file its submissions to the Pay Equity Task Force from 2002 that unfortunately remain perfectly, if not more, relevant today. That report was endorsed by the National Action Committee on the Status of Women, Fédération Nationale des Femmes Canadiennes Françaises, the Canadian Research Institute on the Advancement of Women, and the Disabled Women's Network of Canada. At the outset, we think it's important to note that in 2006, NAL was defunded when the previous federal government removed advocacy, research, and lobbying from Status of Women Canada's mandate, thereby preventing the agency from funding the critical work of equality rights organizations like ours. Since 2007, NAL's National Steering Committee and a group of feminist consultants have kept the organization alive on a volunteer basis. It is in this significantly diminished capacity that we appear before you today, which is really a loss for law and policymakers and for Canadian women broadly, given the very active role an organization like ours could and should be playing in helping government develop human rights and charter-compliant legislation. Because we will be filing our report to the task force that outlines NAL's recommendations regarding the nature of proactive legislation, I will confine my comments today to two critical pillars in the way forward. First, the government must implement the 2004 Pay Equity Task Force recommendations and establish a proactive regime. In keeping with this, it must establish and make public a time frame to get draft legislation on the table for feedback and comment from relevant stakeholders. Second, as part of this committee's mandate, government must ensure funding is available for women's equality rights law organizations to participate meaningfully at federal lawmaking tables to ensure any proposed proactive regime is compliant with domestic and international human rights obligations, as well as with the Canadian Charter of Rights and Freedoms. With respect to our first recommendation, we hope that at this point there is consensus among committee members that gender-based wage discrimination is a serious and costly human rights problem in Canada, and that Professor Bilson did excellent work to chart the way forward. We know that pay inequity is particularly acute for racialized women, immigrant women, Aboriginal women, and women with disabilities. And we know that Canada is attracting sanction by international bodies and domestic courts because of its ineffective action on pay equity to date. It is NAL's position that, in light of both domestic and international commitments and obligations, the Canadian government has a positive obligation to act immediately to table proactive legislation. The adoption of such legislation that applies to the entire federally regulated sector, public, private, large, small, unionized and non-unionized players, and that recognizes equal pay for work of equal value as a human right, is an essential step towards ensuring the respect of women's Section 15 equality rights. This is not a radical claim. This recommendation is consistent with your committee's mandate, with 6 reports of the Standing Committee on the Status of Women issued between June 2005 and June 2009, and with the commitments of the previous Liberal government, and in particular of the Ministers of Justice and Labour, who in fact had mapped a fairly clear path forward in their evidence to the Standing Committee on the Status of Women on November 21st, 2005. It's also consistent with the decisions of our highest courts. Indeed, in 2004, in its NAPE decision, the Supreme Court of Canada recognized pay equity as constitutionally protected by the Charter Section 15 Equality Guarantee. In 2011, after nearly 30 years of litigation, the Supreme Court of Canada unanimously adopted the decision of Justice Evans from the Federal Court of Appeal in the Canada Post pay equity case. In his decision, Justice Evans candidly recognized, and I now quote from that decision, "With the benefit of hindsight, it now seems to have been a mistake for Parliament to have entrusted pay equity to the complaint-driven, adversarial human rights process of the Canadian Human Rights Act."
Ms. Sugarman?
Yeah.
The translators are asking if you could slow down just a little
Sure.
bit. I'm sorry. I'll be a little bit lenient on the time.
Okay, sorry to the translators. Justice Evans also stated at paragraph 167 of his reasons, "There is now much to learn from the experience of provincial pay equity regimes, which seem not to have been plagued with the same problems of protracted litigation as the federal scheme. In the interests of all, a new design is urgently needed to implement the principle of pay equity in the federal sphere. For criticisms of present arrangements," he writes, "and recommendations for reform, see the final report of the Pay Equity Task Force." Finally, with respect to our first recommendation, it bears mentioning that in order to implement the task force's recommendations and institute an effective and constitutional proactive regime, it is necessary to repeal the Public Sector Equitable Compensation Act. Among other things, the PSECA violates the constitutional right to equality by failing to provide an adequate mechanism to address the wage discrimination experienced by women employed in the federal public service, and by denying them any substantive remedy. I can speak in more detail about the unconstitutionality of PSECA during question period if you would like. Our second recommendation is that as part of this committee's mandate to propose a plan for adopting a proactive regime, government must ensure funding is available for national equality law organizations to participate meaningfully at federal lawmaking tables. Without such funding support, government will not have the women's equality rights law expertise nor stakeholder participation it needs to guarantee that it enacts constitutional legislation. The Minister for Status of Women's mandate letter from Prime Minister Trudeau includes among the minister's top priorities that she work with the Privy Council Office to ensure that a gender-based analysis is applied to proposals before they arrive at Cabinet for decision-making. This mandate is consistent with earlier obligations adopted by the federal government, mandating that legislators engage in gender-based policy analysis at every stage of the legislative process. Indeed, the Department of Justice has highlighted the importance of gender-based analysis in legislative drafting. The drafting of new pay equity provisions is no exception. This requires ensuring sufficient funding for women's equality rights experts and organizations to participate meaningfully in the process. It does not require that you reinvent the wheel and attempt to redo what the task force already accomplished to great international acclaim. So to sum up, get proactive draft legislation on the table within an established time frame, and then ensure the funding is in place to properly engage the necessary experts so that you're sure to introduce a pay equity bill that meets Canada's domestic and international human rights obligations. Thank you. We would be happy to answer any questions you have.
Thank you. And that was 8 minutes to the second. Thank you. I would now call on Ms. Perrin, who also has 8 minutes.
Okay. Merci beaucoup d'avoir invité la
Thank you very much for inviting the New Brunswick Coalition for Pay Equity to present its perspective. I will give my presentation in both official languages, starting with French. The New Brunswick Coalition for Pay Equity is an organization of nearly 800 individuals and 91 organizations that conducts education and advocacy for the adoption of sufficient legislative measures to ensure pay equity for all workers in the public and private sectors. Our organization was founded in 2001, but it is based on the study and advocacy that started in the 1980s. In New Brunswick, the wage parity movement developed after obtaining wage parity, equal pay for equal work. In effect, it quickly became apparent that wage parity was not sufficient. Most women occupy different positions than those of men, and those positions were often less well paid. The rallying around nurses' salaries in 1980 led to this movement. They had led a robust campaign exposing the fact that they were underpaid since 1969. In 1980, a study of the Advisory Board on the Status of Women in New Brunswick showed that nurses were less well paid for the value of their work than employees of the Liquor Board, which were mainly men. Thanks to the action of nurses and public support, in 1981, registered nurses obtained an augmentation of 41% over 2 years. It wasn't wage parity, but it was an important victory. Today, most New Brunswickers work in positions that are mainly female. New Brunswick passed a law on pay equity for all of the public service in 2009, but there is nothing to ensure pay equity in the private sector. Although our coalition is a provincial organization and most of our work are done at the provincial level, we've also been involved at the federal level because we know that access to the right to pay equity for part of New Brunswickers falls under federal jurisdiction. We are asking the government to take a leadership role and to finally adopt a proactive law that follows the recommendations made in 2009 by the Task Force on Pay Equity. Its recommendations continue to be a point of reference for us and also across Canada. I assume that you have all consulted the recommendations, but I would like to highlight some of them. First of all, that the legislation must be proactive. It must include norms and criteria to achieve pay equity. Its implementation must be subject to framework for monitoring organizations that are specialized and independent with human resources and sufficient finances, and it must involve the participation of unionized and non-unionized employees.
Right, which is recognized internationally. We expect the federal government to respect this human right for all women and to adopt strong legislation to ensure it is respected by all employers. The current complaint-based legislative framework equates more or less to voluntary measures since few employees have the capacity to lodge a complaint. Even those who are unionized have faced a lot of hardship to get their rights respected, as many others have testified before me. This is unacceptable in 2016. Now I would like to tell you a little bit about New Brunswick's experience with voluntary measures for pay equity. In 2005, the provincial government adopted a 5-year action plan to reduce the wage gap based on recommendations by a roundtable where the most important employers' associations were the majority. The 2005-2010 action plan promoted voluntary measures to ensure pay equity. However, no measurable results came out of the 5-year action plan. Employers did not change their human resource practices, they did not implement job evaluations, and they did not compare the value of jobs that are predominantly female with predominantly male jobs. All we know is that in 2008, a little below 25% of employers had job evaluation systems, but we had no information about the number of employers that had implemented a pay equity system and whether that number changed over the course of the action plan. During that period, the government also introduced pilot pay equity projects for workers in 4 caregiving services provided in the private sector and receiving government funding to a certain extent. In the end, the so-called fair pay the government came up with was $12 to $14 an hour. We asked economist Ruth Rose to analyze the government's reports, and she found that fair wages would actually lie around $20 an hour. She came to the conclusion that pay equity exercises in the 4 caregiving sectors were deliberately distorted in order to reduce the cost to the government. The New Brunswick experience shows that the need for clear parameters so that employers are not permitted to avoid doing pay equity exercises or to adjust the methodology to fit their interests. That's why we support proactive pay equity legislation both at the federal and the provincial levels. And that is also why we support the 2004 Pay Equity Task Force report, Pay Equity, a New Approach to a Fundamental Right. There is no need for further studies. We urge the committee to recommend a strong proactive Pay Equity Act based on the 2004 Pay Equity Task Force report. Now is the time to respect the fundamental right to pay equity and to take immediate action. Thank you.
Merci beaucoup, Madame Perron.
Thank you very much, Madame Perron.
For the very first question for 7 minutes, Ms. Zarovitz.
Thank you very much. I think there's only been a couple of exceptions, but I think we've heard very consistently implement a proactive model, stop with the reports, we have enough, and just move forward. So I think with that in mind, I would love, and you started going a little bit into this, Ms. Perron, so wouldn't mind a little bit more detail. Implementation, there's a complexity, there's lots of complexity. My colleague last night did a wonderful job in saying the concept of pay equity is actually quite simple, and there's no one that's going to disagree with it, but there's a lot of complexity in the implementation, particularly at the federal level. From the examples that we've seen, whether it's Ontario, Quebec, some of the things that's been done in other provinces like New Brunswick, and I'm sure other provinces have had it, from anything that you know in terms of what's been done internationally, what advice would you have around some of the implementation aspects, whether there's a lot of different types of job classifications. How do we start working through some of that? What would be some of your advice around that? We have some federal bodies that are big and small. Do we move a little slower on the small? What are the timelines we should be sort of looking at or considering or thinking about as we're trying to put together that framework? What would be some of your advice around that? So I'm going to start off with that, and then I do have a second part.
Actually, we will have to answer that question after because the bells are ringing, and that means that we do have a bus waiting, so we should be able to get there on time. I do apologize to our witnesses. Unfortunately, this is one of the realities of being on the Hill, and I would ask if it is your pleasure if you would remain while we're voting. It could be up to an hour, including the timing of the bells, but since we had planned to have this meeting extended an extra hour just in case, if that's the will of the committee, then we would just recommence where we left off and then do everything a little bit later, if that's the will of the committee. Okay. Till 9:30. Till 9:30, because we had built an extra hour when we did our work plan, just in case something like this were to happen. Now,
I don't mean to cut anyone off, and so perhaps we might just want to talk with the clerk and with the witnesses. Perhaps we can come back and hear the next set of witnesses and then have questions for all of them at the same time.
We could.
I have some constraints. However, it's the committee's decision.
Okay. Well, what we could do, we'll come back. We can finish with this panel for 45 minutes, which would have been the norm. Assuming it's 7:30, we could ask all 4 to be on the same panel. I know one of the witnesses can only be here for an hour, and then if it goes longer because we have more questions for those witnesses, we can then, the committee can gauge it at that point. Is that?
We can at 8:30, but that's fine.
Yep, okay, and we don't want to miss the votes, so I will be suspending the committee until after the votes. Thank you for your patience. So I want to thank our witnesses very much for your patience. Merci beaucoup pour votre patience.
Thank you very much for your patience.
You were willing to stay. And we will continue with that first question. I believe that Ms. Zarowitz had posed the question, and if you'd wish to begin your answer, go ahead.
So, as far as I understand, you were asking about implementation and advice around implementation, and in particular how to deal with the complexities and some of the complexities that arose out of the Bilson report. And I think what we would say is that the Bilson report, it was as explicit as it was because of how complex pay equity is, and so that we would not advise to start parsing. In fact, I think it's important to take the recommendations as a whole. And I think that it might be helpful to look back at the commitments of the previous ministers of Justice and Labour from the previous Liberal government. When they met in 2005 with the Status of Women Standing Committee, what they proposed was within a set time frame to get legislation, maybe even potentially a few different versions of legislation on the table, and then to hire a facilitator to take that legislation back to key stakeholders for input, which sounds like a fairly reasonable model and something that we would advocate in terms of a good way forward. And then the last thing that I think you asked about was time frame. So, of course, we want to say now, but understanding and appreciating that this is complex and that you want to get good draft legislation down, I think that 6 months from the period of time when you issue your report, you should be in a position to have organizations reviewing draft legislation and providing feedback.
Okay, thank you. How many minutes do I have?
We started it over, so it's at 2 minutes right now. So you've got another 5.
Okay. Okay, thank you for that. Very helpful. I don't know if there were any lessons learned we could learn from the implementation of Ontario, Quebec, and any other international examples you might be aware of. In particular, there are smaller and larger firms, companies, organizations that are part of our federally regulated groups, and so whether there's any advice around that. And then I'll ask a second question, just because, and then whatever time you have left to respond to it. My understanding is that federally, so pay equity legislation is only one part of the solution to close the gap on wage inequity. What are some of the other elements you think we should be focused on as well? So those are my questions.
So do you want to answer the jurisdiction?
Oui. Pour ce qui est des
With respect to the lessons drawn from elsewhere, I think the Quebec model is a good one that itself implemented changes with respect to the model that was adopted in Ontario. Quebec consulted Ontario stakeholders to develop a better piece of legislation, and I think that's a good starting point. One of the things that we're looking at is that for SMEs, it's certainly important to have follow-up, to give training, and also there need to be mechanisms to produce employer reports, whether they're for small or medium enterprises. I'd also like to talk about the issue of the timeline, the time we have to pass an act. We have existed since 2001, our coalition, and we've been told lots of different things by different political parties that, well, we'll do something on pay equity, we'll make changes, and maybe it's time to really take action, and I hope that we won't get into processes that will involve other research, other studies, and then in the end someone will say, well, in our next election platform we'll pass a new bill. I'm becoming a bit cynical, I will admit it. I've been working with the coalition for a long time, and I would be very saddened to see that once again women will be waiting for these changes that just don't come. With respect to the pay gap and other issues, I would like to be careful to not go too far. We can't just do one thing or the other. We need to work on the pay gap. But that can't be a reason to not act on pay equity. That's sometimes something that we've seen in the example that I gave earlier in New Brunswick. I think that instead of working seriously on pay equity, they talked about addressing the pay gap and they talked about voluntary measures, but at the end of the day, there was no substantive change. So I would like to caution you. Don't do things half-heartedly. All of the other issues that can help are access to daycare, employment equity. I know that was often mentioned as well. Thank you.
The next question from Ms. Gladu for 7 minutes.
Excellent, very good. My first question is for Ms. Sugarman. We heard before from the Canada Labour Congress, and when I asked them if they were willing to work with the Justice Minister on the legislation, they said, well, it's a provincial jurisdiction. So based on that, I was sort of confused as to whether that was really true or not. So I know that we want to do legislation, but if you could speak to, is the legislation just about the federal employees, or can we legislate federally for provinces that don't have legislation?
Okay, so I think what we're looking at here is legislation for all federally regulated employers that may have employees working in the provinces, but at the federal level, you can't legislate for the provinces.
Okay.
So I hope that answers your question.
Okay, that was perfect. And in terms of the time frame, we did hear that it took 2 years from the time they started with the Quebec legislation until it was implemented, and I heard you say about 6 months to draft it. Is there any way to sort of make that go faster? For example, if we took the Quebec legislation the way it is and didn't have to spend quite as much time then changing it, or it's already been implemented, it's been proven to be one of the best in Canada, and so do we really need to do stakeholder engagement to implement it? You know, that could kind of cut the time frame down. What do you think about that?
So I think that no matter what you do, once you have good legislation on paper, you're going to have to go back to your key stakeholders. I think that is critical. And I guess the other thing I would say is, while there are, a number of witnesses have pointed to positive lessons that can be learned from other jurisdictions, and in particular Quebec, the federal jurisdiction is unique. And so I think it would be peculiar to draft something identical.
Okay.
Yeah.
Very good. And for Ms. Perron, so New Brunswick has legislation. How is it different from Quebec's legislation?
Less detailed, and that's a problem. It should be more detailed. I think that because the issue is complex, the more detailed the legislation is about what is the process that the employers have to follow, the better it is. In our case, it's not that clear in some cases, and also the timelines are a bit too flexible. There's always a possibility to ask for extensions. It only applies to the public sector as well, whereas we would like to have public and private sectors that are federally regulated for this piece that you're working on.
Okay. And I heard you talk about this one example where nurses had an inequity and they got this 41% increase. And so we've been hearing from witnesses that even where legislation exists and people have done what they can, the wage gap still has sort of a 9% that's not closed, and that people don't understand what all the causes are for that. Mm-hmm. So the question is, do you study the causes or just pay the 9% increase and address it like that? So I'm interested to hear your opinion about that.
would be nice to have the 9% increase for everybody. But no, I don't think it's the way we look at it. It's really dangerous to equate the wage gap and pay equity. Or pay inequity, because really the wage gap is influenced by so many factors. The fact that women are much more educated now influences the wage gap. However, in New Brunswick, we know that women are more educated than men, and still there is a wage gap. So it's much more complex than just looking at one thing. And in all honesty, you could have a situation where you have no wage gap and still have pay inequity. For instance, if you go in a school and you have the same wages for the janitor and for the school teacher, then you don't have a gap, but you do have a really serious pay inequities problem. So.
All right, those are my questions. Dan, do you have one question?
No, actually, I was just speaking with my colleague here. One thing I would like to know is, I believe it was last night we were discussing the Nova Scotia. It seemed that Nova Scotia had a slightly different, I think it was a slightly better track record over the past 10 or so years for the most improved. And yet I think it has a much different legislative framework. Is there, you mentioned that the rules you operate in New Brunswick are less detailed than Quebec, but how would you afford that Nova Scotia seems to have tackled the issue much differently?
I just want to know what you're talking about. The track record on the wage gap?
Yeah, we had. I'm sorry, and I'm again. We've put a lot of hours here in the committee, so it was the most improvement since their initial implementation of it, as far as the gap. So, what might you owe that to? Is it demographics? Is it immigration? Is it legislation?
That explains their success, if you want.
Yes.
Actually,
comparative success.
Yeah, I don't have the knowledge to answer that question.
And fair enough. We talked to StatsCan, and in some cases, they don't either. So appreciate that. Thank you.
Still 1 minute.
Oh, well. Are you?
No, you go for it.
Well, I was not on this rotation. However, one thing that we have discussed a little bit, and maybe I'll just put out to the panel, and hopefully I can do this in a quick enough manner, is in the United Kingdom, they're actually moving forward with what's called pay transparency in the private sector. And what that is that for firms of over 250 employees, they simply put out an average for all the employees, for both men and women, and that's displayed publicly. Now, many of them then form committees and then independently start working at as to the reasons, because every company is slightly different. Some have different dominant genders in their workforce. What does this panel think of that?
10 seconds.
Transparency is good. Does it have teeth? Would be my question. What comes with transparency?
Thank you very much for being succinct. We're going to the next question now, and it's Ms. Benson for 7 minutes.
Thank you very much, Madam Chair, and thank you very much for the presentations. A couple of comments, and then maybe your reflections back on it. I want to thank you for bringing up one thing we have stumbled with a little bit on this committee, and that is thinking we are solving the wage gap with pay equity, which gets us off the conversation around a human right and the fact that we're trying to implement, or I want to implement pay equity legislation so that we have a process in place for all federally regulated employers so that they can implement pay equity and we can know whether they are getting there and how far they have to go and that kind of thing. And I'm not saying that because I don't think the other issues that make the wage gap much more complicated. But I think pay equity legislation is complicated, but the wage gap is very complex. And sending a rocket to the moon is complicated. You just have to follow the steps. A few degrees, I think, like rocket scientist or whatever. And then you follow the steps, which is what I feel we have here with the Bilson report. And so I guess, I mean, I'm not really sure sort of kind of what I'm saying, except that I would like to have you reiterate some of those key pieces about the difference and what I certainly am not someone that thinks we're going to implement pay equity legislation and end sexism and discrimination and be able to tackle all those variables that impact women's lives and vulnerable women's lives. But maybe talk about why it's so important, this piece of work, to women and human rights.
I can start. Well, because it's unfair to be paid less than you should be paid for the value of your work. That's really what it is. And it's unfair that you're not paid as much just because you happen to have chosen a job that is mostly done by women. And it's not fair that you're not paid enough when you're taking care of everybody around you, and your work is paid less than if you were a janitor or a technician, and you are always there to take care of kids in the childcare. You're there to take care of people in their old age, vulnerable people, and you earn $12, $13, $14 an hour. That's wrong, and it has to be fixed. That's really what it is.
And I guess I would add to that pay equity is a recognized human right. And that, at a really basic level, legislation is necessary, not just in order to comply with domestic and international obligations and commitments, but because it's important to recognize that what we're talking about is a situation where work that has been traditionally done by women, and even more acutely by racialized Aboriginal or disabled women, is undervalued because it is considered women's work. The Minister for Status of Women, I think she was here last night, and I believe she said, this is because of patriarchy. So I think, there's a lot to bite off here, but I think you have a template and a blueprint for where to start.
Okay. How may I do? 3 minutes. One more sort of if you could reflect on this piece, and that is we haven't had a lot of employer groups come here. Private employer groups. We've had the public sector, obviously the minister as the employer of the public sector. And we heard from the two largest groups in that private sector, federally regulated group. I think some hesitation to be mandated, legislated to do pay equity. At the same time, although they shared with us they felt they were doing things, and I sincerely believe that they were not able to tell us how close they were, how far they had gone. There were no outcomes, there was no accountability. And I think that will be one of the challenges when we talk about sort of that pushback from employers, because regardless of how often we have said there is a business case, it's not enough to get employers there. So, I guess it's just some of the hesitations from employers, other than the obvious one that you can sort of assume, is it just money?
Okay,
not knowing how big it'll be, I
yes.
guess.
So I guess a couple of things. One is pay equity is the law. So it might be challenging, it might be unpleasant, and it might be costly, but it's the law. And it's human rights law. So it's not the kind of thing that we can dilly-dally on. I guess, I'll leave it at that.
C'est difficile pour nous de parler.
It's difficult for us to speak on behalf of employers in New Brunswick. Well, as I explained, we were part of a round table that looked at the issue of the wage gap. The employers' associations all recognized that there were pay equity problems that need to be worked on, and they said they would change things. on a voluntary basis. But we also saw that that didn't happen. And I think that there needs to be legislation because it is a human right, and also because it will make a fairer world. Everyone will be on the same footing, and the same rules will be for everyone, and I think that's also very important. And it will make things easier to resolve for employers, in my opinion, if they know that all other employers will be in the same situation as them. Thank you very much. That's 7 minutes.
Merci beaucoup, Madame la Présidente, et je vous...
Thank you very much, Madam Chair, and I thank you all for your testimony today. We've often heard from witnesses that it's the time to start a proactive system, and I think that we're all quite in agreement with the witnesses who testified before us.
If we were to recommend to government a proactive system with legislation, what sort of recommendations should we deliver to them about how to work with unions in the implementation of that proactive system? Maybe using examples from the provinces or other experiences that you might have.
So just so I understand your question, do you mean in the implementation process of the legislation?
Yes.
So you don't mean in the legislation itself?
Well, actually, I'd
Or
be
did you
happy
mean
to,
both?
I'd be happy to hear if you had any insight into that at either stage.
Okay, so in the implementation, I actually I think that NAL would stand by what was recommended in 2005, which was that you find a gifted facilitator to take your draft legislation back to stakeholder groups, and that certainly includes and must include the unions for input. So I think on the front end, that's necessary. And I think in terms of what the role is of unions in the actual legislation itself, I think the Bilson report provides a lot of specificity on that that you can use. It's very specific and helpful, and I think it's in there for you.
C'est aussi ce que moi j'ai.
That's also what I remember of the report. There is a lot of detail on the steps to be followed and at what steps you should seek out unions and also non-unionized employees. Employee participation in the process is very important because it is part of recognizing the value of the work of women, work that is predominantly female work, and people can come explain their own work to you. That's also important, and it shouldn't be limited just to unions. My second question would be, if we could start a proactive system, how do we ensure that we maintain pay equity? What are the steps that we should envision to ensure that it's maintained in a proactive system? I think there needs to be directives in the legislation that explain what must be done to maintain pay equity. And also there should be moments to review the work that was done. And the report talks about that and gives directions on that. In the task group's report, there are different sections that address different problems, and there are recommendations for each of the problems that could arise, like maintenance, for example.
You get really specific steps on maintenance regimes, and it gets to the specificity even gets down to at what stages you need to be reporting out on what you're doing. So I would direct you to Chapter 13.
Sure. And maybe as my last question, I'll dig a little bit further at my colleague's question about implementation in a phased-in or using a staged approach. I recall testimony from, I think it was the Association of Labor Lawyers, who talked about maybe making the 2004 recommendations on implementation more palatable by starting maybe with the civil service, and then moving to regulated employers, and then contractors. Would that be a palatable approach in your mind?
I think that, I think we sort of stand by our earlier comment that it's important to take the recommendations as a whole. In terms of a staged, response, I don't think we have the expertise to comment on that.
We have the experience, though, in New Brunswick, because New Brunswick, at some point, there was an election where all political parties promised to have pay equity legislation for all of the public sector, and I believe even the private sector. But when the Liberal government of the time, which was with Mr. McKenna, came in, he adopted legislation for only one part of the civil service. It was part one, the workers in the departments. It didn't include education or hospitals, health, or crown corporations. And so they were supposed to add other groups afterwards, and they didn't. It stayed like that from 1989 to 2009. So phased-in approaches are sometimes another way to delay pay equity. So I would be very worried about that.
I would just add that this is the phased-in approach is incremental equality. We know that taking action is needed now to eradicate the discrimination. It's unlawful conduct not to take those measures right away. So when we know that someone is in non-compliance of the law, we need to act immediately. And the incremental approach, which focuses firstly on the public sector, leaves behind the most vulnerable women and leave them to continue to experience discrimination. And this is, it's not acceptable, it's not in compliance with the law, and it's not in accordance with our international obligations or the Charter.
Merci beaucoup. Est-ce que j'ai du temps qui reste?
Thank you very much. Do I have any time left, Madam Chair?
No, j'apprécie beaucoup.
And thank you very much. That ends this round. And I once again want to thank the witnesses for your patience. Merci beaucoup pour votre patience.
Thank you very much for your patience.
For a couple of minutes while we change the panels, but don't anybody go very far because we're going to start very shortly. Thank you. Call to order, and thank you very much. I particularly want to thank our witnesses who have been waiting. Thank you for being here. In some of the discussions, what I would propose that we do, given that we lost time because of the vote, we do have this room until 9:30, and we do have the video conference until 9:30. However, it was seen that we would end at 8:30. So what we could do is have each of the 4 remaining witnesses do your 10-minute presentations in a row, which would be 40 minutes. Then we'll do our first round of questions, which would be approximately half an hour, which would take us to about 8:30. And then if there are remaining questions, we won't go in the order. We'll just allow anyone who has a question 3 to 5 minutes to ask, and then once there are no more questions, then we will adjourn. Does that sound reasonable to the committee? Okay, thank you very much. So we have with us from the Ontario Pay Equity Commission here in person, Emanuela Heinick, and she's the commissioner. We also have on video conference coming from London, Ontario, from the Business and Professional Women's Clubs of Ontario, Linda Davis, who is past president. Welcome, Linda. Can you hear us? Okay, good.
I can.
Perfect. And we also have, as an individual, we have Mr. Paul Derber, consultant with Opus Mundi Canada. And on video conference from Montreal as an individual, and welcome back, Madame Chicha. I know that you've tried this once before. Well, it was the other day that we had votes, and unfortunately you have a very, very good way of picking the days where we have votes, but we appreciate your patience, who is the former member of the Pay Equity Task Force and a professor in the School of Industrial Relations at the University of Montreal. Bienvenue, Madame Chicha. So we will start then with 10-minute presentations, and we will start with Ms. Heinick. Heinick.
Thank you. Can you hear me? Yes? Okay. Thank you. I'm going to speed read. I've given some notes to the translators, so hopefully we'll be able to get through the information. I've been listening very carefully to all of your questions. I think I would like to tell you about the Ontario Pay Equity Commission, though, and our work in the last, say, 10 years, because we are the oldest of the jurisdictions that have implemented pay equity, and we had a lot of learning to do because we were first out of the block for a long, long time. So just very quickly, the Commission is an independent agency of the government established by the Pay Equity Act. It's accountable to the legislature through the Ministry of Labor. We have 2 separate parts which operate independently, the Pay Equity Office and the Pay Equity Hearings Tribunal. The office is responsible for enforcement. Our review officers are required to investigate, attempt to settle and resolve complaints and objections to plans, as well as to monitor the implementation and maintenance of pay equity in workplaces. And they have the authority to resolve all pay equity issues by order or decision. The office provides a number of tools and interactive material for employers and employees and unions to understand how to do pay equity. And finally, the office has legislative authority to conduct research and disseminate information about any aspect of pay equity and related subjects. So that's the office. The tribunal is responsible for adjudicating disputes that arise under the Act on a de novo basis, but parties must bring their disputes first to our office for investigation before accessing the tribunal process. The tribunal has exclusive jurisdiction to determine all questions of fact or law, and their decisions are final for our purposes, certainly, as the enforcement body. So all Ontario private sector employers with 10 or more employees and all public sector employers must undertake a pay equity analysis, and that analysis process is very well defined in the Act. And I think is the basis for the task force report, actually, in 2004. There is a process to trigger investigations for non-compliance, but the requirement for employers to have pay equity in their workplaces and to ensure that it is maintained is not complaint-based, as you know probably. So the majority of our work now, and has been for quite some time, is really monitoring employers for compliance with the Act. And we have run a number of monitoring. We call it monitoring. Some people might call it auditing, but for our purposes, it's monitoring. We've run a number of programs that have had different focuses and different ways of engaging employers in this process. So we ran a service industry monitoring program between 2007 and 2010, covering, for instance, hotel, motel, retail, and food beverage industries. Over that time, we contacted over 4,000 employers and actually monitored about 1,000 of them to assist them in coming into compliance. We ran a very unique program in 2011, which we called the Wage Gap Pilot Project, and that was an exercise in outreach and awareness and an opportunity to broaden the dialogue, not just focusing on pay equity, but actually introducing the concept of a gender wage gap. In that program, we had a return rate of 81% for the employers that we contacted on a voluntary basis. And we asked them for some basic compensation data. We ran some tests. And we did an analysis to see if they showed patterns of compensation that likely would lead us to think that they might not have compliance. And we found in that pilot that about 54% of responders did have what we called an apparent wage gap. And we then used that to focus our monitoring activities. They were advised if they participated that that could be a likely possibility, and we then started monitoring them. We've also, in 2014, monitored the classified government agencies for compliance. And the 2015 program was an outreach and pay equity awareness program where we sent letters to 14,000 new businesses, basically to make them aware of their obligations and to make them aware of all of the tools that we had available for them to assist themselves in coming into compliance, and also alerting them to the possibility of being monitored. And we're now in the process of starting to monitor those employers as well. So we've gotten a little bit better at measuring our outcomes as well. We're starting to report now on adjustments that we have found to be owing in these monitoring activities. So over the course of the last about 4 years, we have, through our direct intervention, found about $20 million in adjustments owing over a variety of businesses, as you know. And those are only the results of our direct involvement. We regularly see announcements in the newspaper that report on pay equity achievements through negotiations between unions and employers. And a lot of those negotiations do not trigger our office involvement. So we have no way of collecting that kind of data, unfortunately. Anecdotally, we know that because of our extensive outreach programs now and these letters that are going out reminding employers about their obligations, we have seen and heard that there has been a lot of pay equity activity that has been going on, where employers are realizing that, oops, I may have let this slide, and have come into compliance. Our other activities, we have consolidated all of our learning material, and we now have a guide to interpreting the Act, which is on the website and has been widely circulated. And as I said, we have a number of web-based interactive tools that allow employers of pretty much any size, actually, to go in and put their own data through an interactive process and come up with what they should be doing in terms of in terms of pay equity. We've also partnered with other organizations to provide training material. The most recent one has been a partnership with the Human Resource Professional Association and York University, and the HRPA is now offering a certificate program for pay equity, and I was told yesterday that it's their second most popular program, so I think there's a lot of uptake on that. And we also try to disseminate information about pay equity through the various ministries if we have the ability to do so. Now, lastly, we've established a gender wage gap grant program, and we encourage research around pay equity and related topics. So those are the activities that we have engaged in, knowing that our act is at a very different stage than everyone else's, well, except for Quebec. We're both now heavily into the maintenance stage, and I've heard some of your questions, so I'm sure you're going to address some of those questions to me. I would say that our act has not been amended since 1993, and if I were to give you some advice, I would say that thinking about some kind of reporting system would be a very valuable thing to do. I did have the opportunity to revisit the 2004 task force report in preparation for coming here. It is probably the most comprehensive piece of work on pay equity that exists anywhere, probably in the world, I think. And as you've heard tonight, it has covered most of the difficult pieces in terms of maintenance and involvement with the unions, some kind of reporting structure. So it is a really great starting point.
Thank you very much. We will go to the next presentation, which is from Ms. Davis. Go ahead, Ms. Davis.
Thank you. And good evening, esteemed members of this special task force, special committee. It's just an honor to be invited to participate in this really important work. As you noted, I am the immediate past president of the Business and Professional Women's Organization of Ontario.
The interest. We've lost the last. If you might want to start again, because we've lost you for a moment. Sorry.
Okay. Am I there now?
Yes.
Can you hear me okay?
Yes.
Okay, so just explaining that BPW stands for Business and Professional Women, and it's a non-sectarian, non-profit, non-partisan feminist organization that promotes the interests of working women. It operates within Canada and internationally and has consultative status with the United Nations.
Okay, we seem to have lost you again. Can you hear us? Okay, you know what we'll do? While we're working on the technical part, we do have another individual present here. If it's okay, then perhaps we could go to Mr. Derber, have you do your 10 minutes, and then we will hopefully have everything resolved with the technical difficulties. Okay, thank you, Mr. Derber.
Thank you, Madam Chair. It's certainly an honor and a pleasure to be here, and thank you very much for the invitation. I've worked in pay equity in one way or another for about 30 years. And among other things, I've also worked directly for employers and for joint parties, unions, and management. And I've also done third-party adjudication. Some people don't think that I'm terribly independent, but that's their problem, I guess. So I've worked with, particularly with three frameworks, which I think have been at issue here, two proactive ones, namely Quebec and Ontario. actually 4, I'm sorry, and the complaint-driven process which existed in Quebec, as well as the federal complaint-driven recommendations, Section 11. And I must say that I'm a great fan of the Bilson report and recommendations. I do think it's very comprehensive. What I'd like to focus on, and I think this probably fits with your interests, are my experience with Ontario and Quebec and the leadership that has been offered, to talk somewhat about the implementation of proactive pay equity in the federal jurisdiction, about which I have some thoughts, replacing the Public Service Equitable Compensation Act, and why, and some concluding brief thoughts on issues going forward. So in terms of my views on the Ontario and Quebec legislation, I think one of the things that I come away with from the Ontario legislation, there are 2 things. One is the, I would say, the initial go at it was not as fair as it could have been, because lowest paid male comparators ended up being the primary target for making comparisons, whereas in the federal jurisdiction in Quebec it's average. And in fact, later on, the Ontario legislation was amended to include proportional representation. My goodness, that's another topic. Proportional value. I don't know where that came from. And that also is a good deal fairer. And I think one of the difficulties is sometimes as you start, so you end up having to continue. So many pay equity agreements and plans are stuck on the lowest paid male comparator. So I'd urge you not to take that route. And I would hope that Ontario experience will definitely come into play there. I mentioned that Quebec focuses on average comparisons. And the reason for that, as well as under Section 11, by the way, is that if you have 3 male jobs being paid differently, it makes more sense to be able to tell both the employer and the employee that you're being fair by taking the average, neither the maximum nor the minimum. And, you know, I think that's a very simple concept. I don't think we need to go to the moon to figure that one out. Ontario, I think, has exerted a great deal of leadership, particularly on the basic issue of gender neutrality. And one could pause on that issue of bias and gender neutrality because it really goes to the issue of fairness in how you figure out the value of work. And unless you approach that question knowing what your biases are, testing all of the systems, which, by the way, truly need testing, and I'll come to that, I think you will not end up having a proper, supported regime of pay equity. In this regard, I would say the leading jurisprudence on gender neutrality comes from the Pay Equity Hearings Tribunal. And I would certainly recommend, if you're doing any research in addition to Bilson, that certain cases such as Haldeman Norfolk, number 6, there's a whole bunch of them. Some of the employers are pretty litigious, as were nurses' associations, and Women's College. Those are 2 that I would recommend on that issue of gender neutrality. And it's really fairly important. Also, of course, there are a number of Supreme Court of Canada decisions going right back to 1989, and in questions we could maybe cover that if that's of interest, and I'm sure they're all referenced appropriately. Job evaluation, and you've heard the term classification, is an exceptionally difficult discipline to get a hold of. It takes a great deal of detailed analysis, and consequently, because it's the basis of compensation, it's extremely difficult to change. One of the reasons for having proactive pay equity legislation, and I hate to use the word, is to force a re-examination of the very practices of how you value work. And that's a technical term really that follows the issues that you're dealing with here, which is the stereotyping and undervaluing of women's work. Job evaluation is a key tool for doing that. And unless it's reformed, unless there are rules such as they have in Ontario and Quebec, I would venture to say that your reform won't work. Maintenance is clearly exceptionally important, and I'm so glad that you've heard from the Ontario Commission. I've noted a lot of difficulty in Ontario with some of the unions who are trying to push for maintenance in having employers respond. And I totally agree with the Ontario Pay Equity Commission that reporting is very important in the legislation. You know, someone used the word transparency earlier, and having transparency on what's happening on an ongoing basis, on a continuing basis, is very important. And that won't happen unless there's a legislative mandate. I know when I was looking at Ontario experience early on, they had to do a sample, and they couldn't report on particular cases. And I felt that the Commission was somewhat hamstrung in what they were doing. It lowers the incentives to employers in particular, who have to pay the costs, by the way, to carry out pay equity. So I would certainly support very strong measures in whatever legislation you come up with for gender neutrality and maintenance and real incentives. So I've covered reporting. There are reporting requirements in the Quebec legislation, which I think are very helpful. I'd like to speak briefly about the body that you recommend implements pay equity. I would not recommend the Canadian Human Rights Commission, even though I worked for them. As a complaint-driven organization, I think that they have the wrong culture. So I would certainly support a proactive new commission. And by the way, the Human Rights Commission has been unable to maintain its expertise. And the Public Service Compensation, Equitable Compensation Act has not helped. I've mentioned that I think that ought to be abrogated. I don't think it's pay equity legislation, and I can speak more about that. I would also just like to mention in 30 seconds issues going forward, which include proxy, and we can perhaps speak in a little about that. How to treat past pay equity efforts. There will be applications for exemptions, and I think that needs to be provided for in legislation. And Quebec has experience on that. And finally, I think you need to do research on extending the grounds.
Thank you very much for your intervention. It looks like we do have Ms. Davis back. It is possible we may lose the video, but we will have the audio. And so I would invite Ms. Davis to proceed. And apologies for earlier.
Thank you. Thank you. Yes, I don't have the video myself, but sounds like the audio's here, so I'll just jump right in. In the interest of time, I'll just go right to my points, if that's all right. So the gender wage gap, I believe, is a symptom of a systemic undervaluing of women. And I'm not saying undervaluing of women's work. I'm saying the undervaluing of women that exists worldwide. Because this issue arises before employment even begins, I think we must focus on this systemic issue. Establishing equitable pay and compensation scales is part of the solution, but it won't work all by itself. If we don't address the underlying reasons for the pay inequities, we'll not solve the problem, and these inequities will continue to reoccur. Lack of awareness about gender economic inequalities in the workplace is one of the biggest reasons it still exists. The second issue is normalization of the problem. I can't elaborate on these I can elaborate on these afterwards in questions if people want to, but I'll just leave it at that for now. Other factors that I believe are affecting women's choices and affecting the gender wage gap are the care penalty and the caregiver penalty. And I'll assume that you all know what that is. If not, we can explore that again in questions afterwards. I believe there are solutions to these problems over and above the whole pay equity piece, which is absolutely necessary, all of the things being discussed here. But I think we have to begin with awareness in the schools, at home, and at work. And this awareness can be about several different things. About the gap itself, what is it? What causes it? And what are the conscious and unconscious effects of that gap? So I believe that this can be accomplished in a number of different ways. One way is by declaring Equal Pay Day in Canada. I think is important because we have done this in Ontario. We've given it status, and in that sense brought an awareness to that process. So having an Equal Pay Day helps people to be aware that it takes into March or April, depending on the calculation and the numbers used, for women to actually reach that equal pay that men have reached the year before. And that sort of is that aha moment for a lot of people. And it carries on farther. Once you get the dialogue going, you can start to talk about how many more years a woman has to work to be able to, in fact, achieve that same income level that a man has achieved. The other thing would be public media campaigns that would target the problem, the awareness, talk about the bias, the unconscious and conscious biases that are happening. And, there are lots of different ways those campaigns can happen. I believe that we have to target schools, although I understand at the federal level that's probably out of your jurisdiction, but I think that there could be influences happening across the provinces that would make sure that this dialogue starts early in school, to make sure that girls and boys are thinking about all the possibilities, not limiting themselves and not seeing others as limited. I believe that we have to create an awareness in the workplace. So we have to have some kind of employee training that might be similar to health and safety training, where people learn about human rights and about the biases and the effects that the wage gap has, and their rights, of course. I believe government should look at their possessions, their processes, and see how they might bias a family so that the lower income earners may be disadvantaged. And seeing that for the overall good that might happen with the family. And now I'm referring here to things like the employment insurance process and tax laws. So in the EI system, for instance, I believe that should be reconsidered, and to see that parents are being given more flexible time for leaves and caregiving. And this is more to involve men in the process of caregiving and to make sure that women are being paid for short times away. And by that, I mean, your maternity leave and your parental leaves are just part of it. A lot of the other things that influence the wage gap are things that draw women away for short times. Child sick, can't go to school, you can't put them into daycare, and so therefore a parent has to stay home, might be a day or two. You lose income. Many women, especially part-time workers, would lose income for that, and not having access to things like employment insurance for those short kinds of terms. So those are ways that we can influence the wage gap. Tax laws, for instance, may have disincentives for the lower income earner in families, and those disincentives may encourage that lower income earner to lose wages for various reasons, to not go to the next tax bracket, for being exemptions to the family. So sacrificing the wage for the good of the family. And it's the way that the tax laws, I believe, are set up. So we can look at, those are things that government can look at. Looking at universal child care, of course, is also a huge incentive to get women back into the workforce and make sure that we're sharing that care between men and women as child care becomes an option. And I think that would get women who are not considering full-time employment possibly back into full-time employment, and again help to close that gender wage gap. In 2010, the Business and Professional Women's Group that I belong to, their international group became involved with the UN Women and UN Global Compact and the newly formed Women's Empowerment Principles. These 7 principles guide business to a more gender equitable workplace. This is a voluntary program encouraging businesses to sign the declaration and then employ the principles to raise awareness, remove barriers, and promote a gender equitable business model within their company. Since their launch in 2010, over 1,000 CEOs have, from corporate entities with a minimum of 10 employees, have signed the Women's Empowerment Principles statement. I believe that this is a model that could be adopted, and there are 7 principles that we could adapt into, the government could adapt and use as a guide for employers to create awareness in their workplace to closing the gender wage gap. Once created, the federal government could then build resources for employers to use for training, as mentioned before, that kind of employee training, and the tools to use for assessing the overall compliance and equitability of their companies. There are many socioeconomic issues that women uniquely face and suffer from discriminatory gender wage gap, and that only aggravates these issues. Women do not pay less for their goods and services, education, rent, utilities, and other items in our society. And in fact, there's argument that they actually pay more. And yet, our society is complacent about women earning less. Trying to navigate the world that expects the same from same or more, in fact, as what it would expect from a man, but then only rewarding 70% in return, leads to women living in poverty, staying in unsafe relationships, enduring unhealthy situations at work, all because the choices are limited due to this inequality. And so that creates this cycle of socioeconomic issues that are a huge drain on our society. So I think we must stop this cycle.
If you can finish up very quickly, that is 10 minutes.
Okay. Yeah, I think if we can stop the cycle, and it should be the highest priority of the Canadian government. Thank you.
Thank you very, very much. And now, and we did get you visually as well, so thank you for that. Nous avons Madame Chicha, c'est la deuxième fois devant notre comité.
This is Ms. Chicha's second time before the committee, and I hope she's with us. Can you hear us? Yes, I hear you very well. I think it's audio only now, but perhaps we'll get visual as well. You may start. I thank the committee for inviting me a second time to discuss my favorite subject, equality. Pay equity is a fundamental right, as you know, and since it is highlighted by a number of witnesses that you've heard, it's no longer an issue of knowing whether or not it needs to be applied and when, but rather how, and what is the best way to achieve this objective set out by the ILO and ratified by Canada about 40 years ago. I chaired the committee that prepared the Pay Equity Act in Quebec, and I also contributed a great deal to the ILO in Geneva. And I also have taken a lot of training in a number of countries from the ILO. So training on pay equity and others in Portugal, Ukraine. I also did it in Denmark. So a number of countries that are interested by pay equity and that all have an employment assessment method without gender-based discrimination, and that is important. There need to be tools that are gender neutral. And I would mention that the document that I sent to your collaborators explains how to do a gender neutral analysis, and it exists in English, French, and a dozen other languages. It's a very simple document that allows you to familiarize yourselves with what is a discrimination-free analysis, which is the basis for pay equity. In the 1980s, we realized that the complaint-based model that you heard about is long, costly, and very conflict-driven. And when you wait 15 or 20 years to solve a discrimination case in one organization, recent complaints by the Pay Equity Commission in Quebec has been fused into a larger commission. In 2015, in Quebec, 84% of employers had applied the Pay Equity Act, and among companies of $100 and more, 94% of them had adopted it. So it's an impressive result. It's a very high percentage of employers who have applied pay equity. If we had based this on the complaint-based model, it would have taken us up to 100 years to reach that. I think the proactive model has been proven to be successful. So I wanted to focus my presentation on the main characteristics of the Quebec legislation, and I would also like to mention, when relevant, the differences of the task group that I was also a member of. One of the characteristics of the Quebec legislation is universality. That means that all companies, all sectors, all salaried workers are covered by the requirement to reach pay equity. Now, one thing that is not found in Quebec or in other legislation in Ontario is extending it to visible minorities, Aboriginal people, and people with disabilities. And that was highlighted by a number of stakeholders. I think it's something that concerns you, but I will come back to that later. The second characteristic in the Quebec legislation, and I also notice that it's a concern for committee members, is flexibility. In fact, in the Quebec legislation, companies are spread out into 3 different categories based on their size, and the requirements that they are subjected to are much lighter for small companies between 10 and 49 employees, a bit more strict for those that have between 50 and 99 employees, and the requirements are much more structured and high for companies of 100 employees and most. So they take into account the constraints of small companies, which is important. And this is also manifested in the financial difficulties of the company. When the Pay Equity Commission gave a deadline, if they were in an extended deadline, if they were in financial difficulty, the goal is not to trigger bankruptcies here. Another thing I would like to mention is the role of the market. In the case of a shortage, for example, of qualified workers in a male-dominated field where the employer is forced to give a very high salary to attract employees, well, that higher portion of the salary could attract employees who are rare, but it could be considered as discriminatory against low-value, traditionally feminine work. There's also one of the problems is with reactive legislation is that things are not spelled out very well, and there are conflicts that are very long between the parties when it goes to a court or it goes to tribunal or the Human Rights Tribunal. In proactive legislation, the thresholds are specified for female and male-dominated fields. The evaluation factors are spelled out, as is compensation. And I would say that the salary comparison can be used, but not that of the average value. It's a comparison. Well, there should be not the average cost, but the regression cost. And proactive legislation like that in Quebec needs to set deadlines and a calendar. In Quebec, it wasn't too long. 4 years were given to employers to establish a pay equity plan, and then another 4 years were given to pay the adjustments. In the working group, we suggested 3 years to draft the plan and 3 years to pay the adjustments. I looked at the Swedish law, and it was also 3 plus 3. So it's more limited. One of the issues that arose with other experts is the fact that you would perhaps, like Ontario, have to scale it out. So for the first 2 years, it would be large companies, and then it would be 2 years for medium, and so on. But if you give 3 years to all companies to establish a pay equity problem, that will solve the problem, because small companies could wait for the 3rd year to do their work, and large ones could start on it in the 1st year. So I favor the uniformization of the implementation. Another characteristic that is very important in the Quebec legislation that is distinguished from that of Ontario is the structured participation of representatives of salaried workers and employers' representatives. Employment equity task forces is a requirement for all large companies, but not those that are smaller. 50% of the representatives of salaried workers must be women. And why is there this participation? It is because the work of women in female-dominated fields is often invisible. Everything that has to do with responsibility for others, communications, they are in female-dominated fields, and they're often invisible. But in reality, the participation of salaried representatives, and particularly women, we try to find solutions and share the issue of invisibility. What is invisible is not evaluated, and what is not evaluated is not paid for. That's a very important issue. The other advantages of the participation, that it reduces the costs to government. The Pay Equity Task Force already has a lot of things to accomplish. So if it's done within the company and it's adapted to the company, it is flexible and it takes into account the specificities of the company and it accelerates the process. When this is done within the company, it goes much faster, and it's not up to the commission to decide what is done at a certain step and what is done at another. So I think the participation is really something that must be structured. It's very important. And another characteristic is transparency. Transparency means that the employer will give the necessary information to members of the Pay Equity Commission so that it can do its work. Excuse me, Madame Chicha.
D'accord, merci.
Thank you. I would like to come back to that. I would like to talk about the intersectionality, which is a problem that often arises. Once again, there's the issue of Aboriginal people and individuals with disabilities and visible minorities, and I could get into that in greater detail in the questions and in the answers to the questions. I would also like to highlight, well, we talked a lot about regression studies done by Stats Canada, which attributes each aspect of the wage gap to a certain thing and says that it could be unexplained discrimination. As I just said, and I will wrap up on this, pay equity and pay gaps, it's pay gaps between jobs of equal worth. We don't find the overall compensation, which is part of pay equity. And so I think that we must not have illusions. The regression studies by Stats Canada must be well done and robust, and they don't concern pay equity as it was defined. Thank you.
Actually, that you were our very first witness when we started the committee, and you are also among the final witnesses. So thank you so much. There's obviously a lot for us to understand, and I'm going to go directly to the questions. We will start with Ms. Zarowitz for 7 minutes.
Okay. I know that, first I want to thank everyone for their presentations. That was amazing. My head is about to explode with all the information that's come in. I know that, Ms. Haynick, you have to leave soon, so I'm going to address my questions to you initially. I understand the federal jurisdiction's unique. My question to you is, what could we learn, though, from the enactment and the implementation of a proactive pay equity legislation in Ontario? And I'm going to be specific. I heard your advice around reporting. Okay. I want, one of the recommendations in the Bellson report was that pay equity should be removed from the collective bargaining process. If you could let us know whether that was removed in Ontario and whether we could learn from that. So that's one aspect. Second is, my understanding from the Pay Equity Tribunal that was set up, there has been a decline in terms of the number of cases that's come before it, even though it seems like pay equity has been, the gender wage gap has been increasing in recent years. And wonder if you can actually talk to us about the tribunal, whether there's something we need to be concerned around there. And lastly, on the flexibility, I think it was Ms. Chicha who talked about in the province of Quebec they had the 3 groups, and whether that's the same type of grouping and whether it's worked in Ontario, and whether you'd recommend that at the federal level.
So on the issue of the wage gap going up and the tribunal cases going down, I don't even know how to answer that. Pay equity is not about the gender wage gap. I think you've heard that multiple times. I think that the cases that go forward to the tribunal have never been very many. I think in the initial stages, of course, when people were testing the system and how far the flexibility could go within the processes that were laid out, there were certainly much more jurisprudence, but the jurisprudence now, or the cases that go to the tribunal now tend to be testing charter issues, law-related cases, and some of the maintenance requirements around the proxy method, which we didn't really talk about and is very, very technical, and has had mixed results in Ontario, I'd say. So those the fact that the gender wage gap is fluctuating, and the case level at the tribunal really has absolutely nothing to do with one another. I would say that the cases that go to the tribunal tend to take a long time because they're de novo, and usually they're union cases where, as I said, they're trying to test something out. Most of the issues resolve at our level, at the office level. So on the issue of the collective bargaining piece, that one is, I guess it depends what union you talk to. Some unions are very averse. Most unions are, I would say, averse to mixing collective bargaining with pay equity because one is a human right and the other one is the normal give and flow of collective bargaining. Our Act integrates those two concepts from the perspective that unions and employers are prohibited from bargaining anything that, if implemented, would bring about a contravention of the Act. So that's sort of the prohibition. And then any pay equity agreement that results supersedes a collective bargaining agreement. So that's how the two acts interact in Ontario. If you were moving forward, I would maybe suggest that you look at some mechanism for tying those two processes together. They can still be distinct, but from a timing perspective, it would be really advantageous, perhaps, if there was some ability to coordinate what happens at collective bargaining and then relate it to a pay equity process. So, something, for instance, and I haven't run this by stakeholders, so I'm simply making a suggestion, but you could do something like having a term in the collective bargaining agreement that is a sign-off on pay equity, that they've considered the pay equity consequences of a particular collective bargaining agreement. And if there isn't a sign-off, having a time frame within which to bring a complaint about pay equity, for instance, to the Commission, so that there isn't a lot of overlap. What we find in Ontario is that sometimes you will have 3 and 4 collective agreements, and then one of the unions will bring a pay equity complaint, and it makes it very difficult to go through several collective agreements to determine what the pay equity consequences are. So having some ability to bring those two together and yet keep them apart if the parties wish to do so, that would need to be respected. Having said that, there are lots of employers and unions who have negotiated terms of reference on how they're going to deal with their pay equity issues. And that has evolved over time. So it would be probably good to consult with unions and determine what some best practices are around that if you're leaning in that direction. And the other question was around flexibility, and I don't recall that.
Basically, I believe Ms. Chito was talking about how there was some flexibility in terms of, I'm not sure if it was around the rules or implementation, between the 10 to 49, 50
Oh, size of employer, you mean?
Employer, yeah.
So when our act was implemented, it came into effect all at once. However, it was staged in terms of larger employers had to go through a plan, and they had a certain amount of time to come into compliance in the sense that they had to adjust their current compensation practices to provide for pay equity, and that was done by size. Whether you need to do that now, that's a question of, I think it would depend on the unique nature of the federal jurisdiction.
Thank you. That's the 7 minutes. So we will now go to Mr. Albus for 7 minutes.
Thank you, Madam Chair. Thank you to all of our witnesses. I'm going to start with the Commissioner. Commissioner, thank you for coming today. I'd just like you to elaborate a little bit further about the Public Service Equitable Compensation Act. You said that you could understand the perspective of unions not wanting to have linkage between, the necessity of dealing with pay equity. And you've offered that there could be a process where that it's still resolved with unions, because I believe the employer and unions both have a responsibility to be able to deal with these issues. So can you just elaborate a little bit more on the model that you'd be talking about?
Well, I would hate to call it a model. It's simply a suggestion that our experience is that in some of the cases that come before us, and I think you have to appreciate that we don't get a lot of complaints, actually. So the complaints that we get are probably not indicative of what is going on in the broader public. Some of the more difficult cases that we have that come forward as complaints are situations where there have been a series of collective agreements and then pay equity is bargained or brought up at a different time frame. And all I'm trying to say is that it makes it difficult. It makes the investigation more complex if you then have to sort through the potential pay equity impacts of various collective agreements. I'm not suggesting a PASICA model. I haven't really looked at that model, and I would not. I would not want to comment on it because I really haven't studied it very carefully.
And I could just see that the Treasury Board President was here the other day, and how difficult it must be dealing with so many different unions of different sizes and different focuses and whatnot.
Well, the Ontario Public Service is very similar. I mean, they've managed to go through that, and I think that they have over time developed processes with their various unions. We get very few, if any, complaints from the Ontario Public Service, actually, I must say.
Sometimes it's just the newness of the model and whatnot.
Yeah, okay. I think like every new model, there's going to be a period of time that will require an adjustment for all parties, and you just have to plow through that and learn from the experiences of Ontario and Quebec in getting through that.
Okay. Now, I have a number of questions, and hopefully we can, because you're one of the few witnesses we had that is actually in the field, dealing with these issues every day in a substantial way where you have to work with everyone. Mm-hmm. First of all, your yearly budget.
Oh, our budget is just shy of $3 million, and our staffing complement is 25.
Okay. How many departments do you have in it? Is it obviously
with
very
25
small?
People?
Yeah.
We have 15 review officers. We have a program specialist, we have a legal counsel, and we have the complement of admin staff.
Okay. So do you have one central office?
Yes.
Okay. Is it near Queen's Park? Is it?
We operate, downtown Toronto, yes.
So Ontario is quite geographically large and diverse. How do you deal with that?
Well, like I said, most of our activity is now monitoring for compliance. So we just decide to monitor. Sometimes we monitor sectorally, sometimes we monitor by geography. It depends what the focus of our program is and where we think that there are pockets of non-compliance.
Okay. So how many?
A lot of this can actually be done on paper. At the end of the day, what you're really looking at is compensation data. And how it's been allocated between male job classes and female job classes. And You can do quite a bit of that by email exchanges, by asking for specific data that you're looking for, and then having that data appear. We have some review officers that do field visits. We have other review officers who are quite happy to do all of this work and manage to do it quite nicely from their office.
So typically, let's talk about is it someone in the field that hears a complaint that triggers an audit, or is everyone asked to comply with a yearly? You mentioned the importance of reporting.
We don't have a reporting structure in Ontario. That's why we've chosen, and that's why I would recommend that you consider having a reporting structure. The reporting structure allows a few things to happen. First of all, it's an opportunity for everyone to wake up and say, oh dear, I have something to do that I may have not done. So it's a point of contact on the issue that allows them the opportunity then to become compliant, especially in a proactive environment where the expectation is that you are doing it.
Okay, and I don't mean to be rude. I'm just trying to get to a couple more questions here. So when it comes to, are all companies then underneath your legislation, or just certain size of companies?
All private sector employers with 10 or more employees.
Okay, so for small businesses with 9 or less, okay.
Yeah.
Okay, are not included.
Yeah.
Okay, and now when you talk to reporting, how do you report? Do you report to the Legislative Assembly in Ontario?
We file annual reports they go through the ministry to the legislature, yes.
Okay. Now, one area that we've been wrestling with here, at least I find it, is that when we had Stats Canada come in, we asked for a number of different areas, and unfortunately there's still unexplained components, there's lack of reporting for bonuses, et cetera. And there doesn't seem to be any kind of comparison, because we've heard much about the proactive model, but many provinces do not use the same proactive model as Ontario. So the national average, some of the averages that we've seen at the committee in the testimony, there seems to be a trend that it is narrowing.
Are you talking about the gender wage gap number?
Yes. So how do you say, and I'm not taking away any of the work that you do, but how do you know, and how do you give legislators the knowledge that what you're doing is in fact materially having an impact?
In just a few seconds.
By the fact that when we go in and have to order or find that adjustments are owing, that means that there is a gender bias in the valuation of women's work.
Okay, thank you very much. That's your time. We'll move on to Ms. Benson for 7 minutes.
Very much, and thanks everyone who are here in person and video for your presentations. And I guess the one piece that I think sometimes we are sort of struggling with is the outcome to pay equity legislation and what it's intended to do. Because my understanding is the gender wage gap is an issue much broader than what we're talking about here, and that is a human rights issue about women being paid differently because they are women as opposed to men. So that's the intention of pay equity legislation, is to find a way for that human right to be implemented. Is that correct?
Pay equity and equal pay for equal work are probably the two most common and known ways to value women's work because it has been traditionally undervalued. The impact that it has on the gender wage gap would be impossible to measure. We have tried, I've had lots of conversations with Quebec over this issue, and at the end of the day, and I'm not a statistician, so I can't really tell you why, but the wage gap is caused by so many factors that have nothing to do with discrimination. They have to do with accessible childcare. They have to do with part-time versus full-time work. They have to do with choices that people make in terms of careers that they go into. And yet those careers that they choose sometimes are undervalued because they're women's work. So there are way too many factors to be able to say this thing will do that to the wage gap. I think if you step back, and I think it's unfortunate because now we spend too much time focusing on some number that even statisticians have a difficult time explaining. I think when you step back, you say, you know what? We have a gender wage gap, and it demonstrates that there are gender stereotypes and social norms and biases that are creeping in everywhere in our system, and those need to be addressed. And then move that aside and really look at the issue is really women's economic participation. You have a labor force now that is mostly women, or 50% women, and we have graduation rates at all levels of schooling that is primarily done by women. And are we getting our return on our educational investment, both as a society and as individuals and as families, if then we don't value the work that women do in our society just because they're women, as I think the witnesses from NAL said. So it's an economic issue, really. And I think if you get hung up too much on is the wage gap 30% or 28% or 26%, you're really not getting to the issue. And you're allowing that conversation to take over when everybody knows what many of the remedies are. So if you start looking at countries where the wage gap is consistently very narrow, you will see that there is a panoply of support systems that allow women to participate fully in the economic sphere. And to me, it's definitely a human right. Without a doubt, it's a human right. But boy, it's also a big economic issue. And if you're going to undervalue half of your labor force, I think we should all be giving our heads a shake.
Thank you. And Mr. Gerber, I just wondered if you could, I sort of took your comments as someone who has been in the field practicing under a variety of regimes, because you've been around when things weren't there wasn't a lot of structure. It was complaint-based, and of course now you've had a chance to work under legislation at the provincial level. So I sort of took your comments as these are some of the things you need to think about from what we know under what has happened already. And I'm wondering, maybe give two that you think are the most important that we need to learn and listen from your experience in the past. Like you've talked about gender neutrality and sort of the average wage. You've both mentioned proxy, and I'm not sure if we should even get into there, but if you wish, please, you could comment on that.
Perhaps I could start with proxy very, very briefly. I suspect that there are not a lot of predominantly female organizations in the federal sphere that don't also have male comparators, but there will be some. So there does need to be a process. I know that there are some small, for example, councils where you would find professionals at the, pardon my expression here, professionals at the top and support staff at the bottom. And you can't figure out what the proper relationship should be. If they're federally funded, then there ought to be some way of figuring out what a fair wage would be. But I have to say I would not use the Ontario proxy approach for a number of reasons that you might want to get into later, but mainly it's too complicated. And Quebec is entirely too simple. So you know, there needs to be some way of working on that. In terms of what ingredients are most important, very clearly the commitment of parties is by far the underlying force behind any kind of pay equity. And I mean commitment by employers, commitment by unions, and commitment by non-organized employees. I think it's a little bit of a mistake in the Quebec law that under 50 employees, the employer can do his or her own thing. I think there needs to be participation. Is that it?
Yeah, I'm sorry.
Fine.
We have to go to the next question, and it is to Ms. Sidhu for 7 minutes.
Thank you, Madam Chair, and thank you for all the presentation, and I'll share my time with my colleagues too. And my question to Ms. Davis. You have publicly pushed for ending the gender wage gap in Ontario by 2025. As a founding member of the Pay Equity Coalition of Ontario, you point out the 12 specific steps. Can you would these strategies work for federally as well?
I believe they will. They are based in employment and also in human rights. So I think that they could be adopted into the federal profiles.
And to Ms. Chicha, you have mentioned the post that non-unionized sector are where some of the biggest challenges are reaching pay equity. In your opinion, what specific legislative strategy allow us to target non-unionized and more precarious sectors?
Well, as I mentioned, universality means that it applies to all sizes, all sectors, all employees. Now, for non-unionized, in fact, you're right to say if it's a non-unionized enterprise, it's different from if it's an enterprise where some employees are non-unionized and some are unionized. Because in the Pay Equity Committee, all employees must be represented, even if they are non-unionized. But in non-unionized settings, especially in small enterprises, where you find many immigrants, many visible minorities, it's a problem to reach them and to make the act being complied with. So the Pay Equity Commission of Quebec is now doing some work. And I'm invited to comment on this work next week to see if this would be an efficient way of reaching non-unionized employees. I don't know if this answers your question.
Yeah, sort of. And to Mr. Gerber, can you speak about some of the successes and challenging during the formation of a Bilson report?
I'm sorry, the formation of?
Bilson report. Beth Bilson report.
The Bilson report.
Bilson
report.
report.
I'm sorry, the Bilson report.
Yeah.
Excuse me. My hearing must be going. I'll blame it on old age. I think that I would support all or almost all of the Bilson recommendations. I think what you have to do, you don't have to do anything, but you should consider is ensuring that equity applies equitably across the jurisdiction. And it doesn't at the moment because of the PASICA legislation, which effectively takes away pay equity from the public sector, in my view. So I think that that is somewhat of a difficulty in getting proactive legislation. I'm not sure that answers your question, Ms. Sadhu.
Any successes of, do you think, is there any successes, if you think, and which successes you want to elaborate for the
Successes in pay equity? Yes. There are a lot of successes, particularly in Ontario and Quebec, where largely unionized employers have moved a great distance toward pay equity. I would characterize proxy as somewhat less successful in Ontario, in part because of the mathematical formula. There are some people, for example, who it will take 30 years to achieve pay equity, and I don't think that's reasonable. So it was an enormous success to get all of those para-public, if I could use the Quebec expression, organizations covered by pay equity. Great success. The difficulty has been making sure that people actually end up with good pay equity settlements. There are many, many successes in terms of reforming job evaluation. Many, many successes. And I think, by the way, that those models should give us all the confidence that proactive legislation in the federal sphere can work. It's worked elsewhere. I think it can work very well in the federal jurisdiction.
Okay, thanks.
1 minute, 10 seconds.
What do you want to take
Mr.
over?
Sheehan?
My question was answered by Emanuela through a series of other questions, and I know that I believe you had to leave at 8:30 and it's 1:45, so.
I have to leave now.
Okay, thank you. Thank you. My question's been answered.
If you have other questions that you want to send to me, I'm quite happy to answer them if I can. So, but I do have to go. Thank you very much. It was a pleasure.
Thank you very much, Commissioner. It's been very, very useful. I'm going to move to the open list. So I'm going to keep a speaker's list. So if anybody wants to ask a question, and so far I have Mr. Longfield. Yeah.
Yes, thank you, and thanks for having me as a guest on this committee. I have a couple of questions, but I'm very interested in Ms. Chicha's comment about the implementation. So I'm picturing myself as a former business person with several employees under payroll, and how we would adjust to legislative change, knowing that you also have to stay in business. So the Pay Equity Commission in Quebec would be in place to help to evaluate the delta between what you're paying and what you should be paying, and then having 4 years to work your way into that through some type of a granting system. Am I understanding that correctly? And that there would be a 4-year pay down. Like there's a staged input or a staged implementation to ease the burden on employers to get towards pay equity?
Yes, in fact, all proactive legislations have this approach to by steps. I mean, so in Quebec, the first 4 years are devoted to do the pay equity plan. So a small company can start, at the last year or even the last month, right. Because from people I know who have implemented pay equity in small enterprises, it takes them approximately 1 week or at most 2 weeks to do the plan. So it's quite easy to do it. But for large enterprise, they can start earlier.
Right, and that's.
I don't know if this answered your question.
I think so. The first part of the process then is getting your ducks in a row. I don't know how else to say that. And then the once you've agreed on the settlements, then there would be some method that the government helps you get towards the goals that you've determined in the first part of the process.
In fact, this is done by the employer and through the committee, the Pay Equity Committee. It doesn't need to go to the Pay Equity Commission.
Okay.
It's done independently, but following the guidelines of the Pay Equity Commission.
Super. Thank you.
Professor Chica, you had talked about. I think this has been very helpful for me when because I was sort of cringing around talking about legislation being incremental, but I see the incremental piece comes perhaps at the implementation stage, and that all employee groups, employers get a time period in which to do their plan, and then a time period in which to actually get to the financial, end goal if it's large and they can go over years. And so you've said that in Quebec it's 4 and 4, in other places it's 3 and 3. Is there any science to the time? Or they just pick that out of the air, or does it make sense? Does it work?
I think that it's essential to have some time to do it, but I find that 4 years it's too much. Maybe because the guidelines were long to produce, and then they wanted to help employers and employees in giving them all the tools, so they thought maybe it would take 4 years. I really don't know exactly why it was 4 years, but as a chair of the task force who advised the government on this, we were against such a long time, because it takes finally 8 years to get the pay adjusted.
Right.
But 2 or 3 years, 3 years were suggested by the task force, the federal task force. So I think that 3 years would be okay.
Okay, next question, Ms. Zarowitz.
My question's to Ms. Chica. You've done a wonderful job of, I think, you've done a lot of work internationally, you've done a lot of work in Quebec, you're very familiar with the Bilson report. I want to ask you about best practices around compliance. So I'm sure around the world there's different compliance numbers between whether it's unionized or non-unionized, or different groups, whether it's large employers or small employers. I just wanted any advice you might have, or anything you want to share with us in terms of how do we ensure the highest level of compliance if we're sort of making some recommendations or creating legislation. Any advice around that?
Yes. In fact, in one of the work that you have, the comparative analysis that I think you have, your committee, I devoted a chapter on best practices. And I think what is essential as a best practice, if it can be called like this, is the Pay Equity Commission. Without a Pay Equity Commission, everyone could be confused, work will not go swiftly, etc. So Pay Equity Commission is essential. Another thing is the joint participation. And as Mr. Derber said, it's a mistake in Quebec that we don't have joint participation in small enterprises. I agree with him. So joint participation will make the process much more easier, much more adapted to the enterprise. And so this is joint participation. Something else is training. And in Quebec, there is a compulsory training that the employer should give to members of the Pay Equity Committee, so they are able to do their work. Because we cannot say that pay equity is not a technical job. It's technical. So you need training if you want to do it well. Another thing is transparency. And in a survey I did in Quebec with those who were responsible for pay equity implementation, they mentioned that when employees or employee representatives think that the employer is hiding some data, finally they don't have confidence in the results, and it may entail, conflicts. So this is another one is communication. The communication must be done very well with the employees, so they understand what is going on. They don't have expectation that all the women in the enterprise will have a raise of 10% of their salary. Communication will lay the ground for a better understanding and acceptance of employees. So I think these are some of the most important best practices.
Great. I do have one more question. Well, the world of work is changing. So we have a lot more, whether it's precarious work, we have a lot more short-term work contracts. Moving forward, because we're also thinking about the world moving forward, is there anything specific that we need to be thinking about in terms of, as we're sort of thinking about pay equity legislation, that we should be considering? And this is to anyone who wants to respond to it. Is there anything we need to think about to accommodate that?
I think that for precarious workers, it's much harder for them to claim, to mention that they need to have pay equity, that the pay is, there are discriminatory practices. So they need some support from either the Pay Equity Commission or other bodies, because otherwise they won't be able to benefit from the pay equity due to their very vulnerable situation.
Mr. Derber?
Yes, what was I going to say? I think one of the difficulties that we have in the federal sphere is that we have one extraordinarily large employer. We have a number of crown corporations, many of whom I would say are following very good practices. And I would humbly suggest that the federal employer has fallen behind. The last time it looked at pay equity was 1985 to 1989. In the meantime, their tools for valuing work date from the 1960s, very largely. They do not measure skills, efforts, responsibilities, and working conditions. All of them. They don't. There are perhaps 6 in all that comply with pay equity legislation out of 72. So that, I don't know whether that's the tail of the dog, because it's such a large employer, such a large employer. But that, I would say, is a major challenge that requires a focus on the part of the federal employer that will only come through legislation.
Ms. Davis, did you want to add something?
I would like to say that the precarious workers of the 21st century really have no voice, in the sense that the types of employment that they're engaged in and contract work and things like that. So I think that's one of the key areas that we can help with, is trying to bring those workers together in some form to have some sort of collective voice, so that they can advocate for their work environment and access to benefits and all of those things. And those are really key issues that add to the wage gap and the value of the workplace and the value that work is being done. So I think it's one of the key areas that we have to look forward to going forward.
Okay, thank you. And we have a question from Ms. Benson.
Quick one, I think, Mr. Durer. I wrote down a comment you said about past pay equity exemptions.
Right.
And I don't know if you could...
What does that mean?
Yes, thank you.
Well, there may be claims that by employers, notably, that they have done pay equity, and therefore it's unfair to put more demands on them. That happened in Quebec, and all that is needed there is a process for looking at what has actually happened. Do they have a plan in place? Is it maintained? Do they, for example, have an audit mechanism for figuring out where they stand in terms of equal pay for work of equal value? That may or may not have to be in legislation. It could be in policy. It's certainly part of what Madame Shisha talks about in terms of a strong commission and strong reporting.
We have the others want to answer that question, or we'll move on to Mr. Longfield. Sorry, Madam Chichi.
Yes, I would like to add, maybe it's not directly in connection with what the question that was asked. It's about the reporting, because you talked a lot about reporting, and I was not able to mention what is reporting in Quebec. In Quebec, every year there must be a report sent by every employer. To say it's a very short form, just one page with 3 or 4 questions. Have you done pay equity? Have you maintained pay equity? Like this sort of questions. And this allowed the Commission to say, as I mentioned, that 94% employers with 100 and more were applied the Pay Equity Act. So reporting is very important, as the head of the Pay Equity Commission of Ontario said also, because it reminds the employer that they have to done some work, and if they haven't done it, there are very high penalties that they have to pay for this. So I think it's not a very heavy burden, but it's important to do. And in Sweden, every 3 years, the employer must submit a report which is much more detailed than this one I talked about, but I think it's really essential to have one.
Thank you. Mr. Longfield?
Yes, thanks. There's a comment that Ms. Davis made that I was interested in terms of the caregiver penalties, or the versus what we're looking at through our campaign as the government. We looked at, or we're looking at implementing an EI system that'll have a care program that will allow sharing of time off with either 2 6-month periods or 1 18-month period. So we're looking at the EI system differently and looking at trying to improve care. But I think there's a bigger issue is the aging population, and that hasn't been part of this discussion, the retirement wave hitting. So I'm bouncing a couple of topics around here, but have you seen the EI system that we've been talking about, and whether you had a comment on what we were proposing during our campaign?
I haven't looked specifically at that EI system, but I would say that one of the shortfalls of EI has always been the inflexibility of taking time. And so being able to take short periods of time and be compensated for that. So in Ontario, we have job protection for short periods of time for caregiver leaves, but there's no compensation for that. And sometimes what we see in the caregiving leaves are even shorter than, you don't have somebody who's critically ill. You may have family members who are just somewhat ill. But if I can just elaborate, the caregiver penalty, or the care penalty, really refers to that penalty that you get if you go into a caring profession that is undervalued and underpaid, but you choose to do that because you care about the individuals, whether it's child care or home care, and so you sacrifice pay, and women do this all the time, and men sometimes as well. So that's the care penalty. The caregiver penalty is that penalty for taking time off to take care of sick, and that again tends to be women.
Perfect. Thank you for clarifying that. And I think, I mentioned the retirement wave, and I think we're sitting at a very, opportune time to make changes when we have a large number of people exiting the workplace. We have to look at our existing workplace and look at it differently. And that this applies to immigrants that aren't being paid what born Canadians are being paid. It applies to people with disabilities. So hopefully through our discussions and going forward, we'll be able to address not only the women's inequities, but all the other inequities that are sitting there for the force that we have to draw from, and quite the challenge in the next 10 years.
Okay, are there any other, Ms. Benson?
A quick one to both Mr. Gerber and Madame Chica. How long do you think it should take for the federal government to implement, to create the legislation and implement pay equity? If we were going to give them some advice on a time period in which we would like them to have it implemented, I guess. So I can go Mr. Gerber first and then Madame Chica.
Well, there are obviously two phases of for legislation. One is getting something passed, and the other is having a commission in place. I think it takes a little longer sometimes to put the organization into place, to find the expertise, to ensure the appropriate leadership. And I would suspect that further consultation on the legislation, etc., is likely to take you 6 months to a year. You, I'm sure, are better placed to know about those political realities than I am. But I can say from my experience in helping to organize various places that it does take 6 months to a year to recruit the appropriate people, to determine what your plan, your organizational plan is, to ensure with government that you are really clear on the mandate, and to actually have people in place so that the right signals can be sent. And so I would say probably 1.5 to 2 years.
Professor Chica, and comments about time?
Yes, about time. In fact, in Quebec, the act was passed in 1996, but it went into effect for employers in 1997, and the reason for that was to allow the Pay Equity Commission to be installed, to hire people and to develop expertise. So it took 1 year almost for the Pay Equity Commission to be able to work. But to pass the act, I mean, we had 1 year to prepare as a task force, to prepare the blueprint for the government, and then there were some negotiations with the partners, with the social partners, and I would say 1.5 years before the act was passed, but we went from scratch almost. But here you have already the Pay Equity Task Force recommendation that I think many people agree on, so you have already some lead in this work.
Are there any further questions? No? Okay, do any of the witnesses want to have some final words? Mr. Derber?
I would just quickly like to...
Mr. Derber and then Madam...
Sorry, Marie-Thérèse. I would just quickly like to underscore the difference between pay equity in an organization and the wage gap. That legislation should not hold an employer responsible for closing the more general wage gap. I think that would be quite unfair. In fact, I remember when I was at the Human Rights Commission, the Bankers Association was very adamant about that. And all they're responsible for is the treatment of their employees. So I just like to say that quickly.
Thank you. Madam Chica?
In fact, I was going to say the same as Paul, because I noticed by reading all the hearings, the experts, etc., that there is some confusion. As it was mentioned today, the wage gap is due to many different causes, which are discriminatory, but it's not wage discrimination. And each part of this wage gap, which whether education or experience or family and work conciliation may be closed by different types of policies, but pay equity is a different policy that deals only with the pay discrimination or the wage discrimination and not all the wage gap. So employers can be afraid of thinking that the wage gap, which is 20%, will have to be compensated by them, but it's not true. It's the adjustments are around 5%, 6%, depending on the jobs. So I think this is extremely important to be very clear about this. And I will add, if you allow me, when the Pay Equity Act was passed in Quebec, this act was initiated by a different party from the one that was at that time at the government, which was the Liberal Party, and the Prime Minister was away for a mission, and he asked that the passing of the act will wait for one day until he comes back, because even if at the beginning he wasn't in favor of this Pay Equity Act that was passed that was presented by a different party, he wanted to manifest his support to pay equity, and the act was passed at the unanimity of all the parties in the National Assembly of Quebec, and I wish that it will be the same at the federal level, if I can wish something like that.
Thank you.
So thank you very much.
Very much. And Ms. Davis, did you have any final words?
I would just like to actually disagree with my esteemed witnesses and say that in 25 years in Ontario having the Pay Equity Act, we have not closed the gender wage gap. And I think without looking at both problems simultaneously, introducing pay equity without introducing measures to close the gender wage gap, you will simply be, going in circles and having to continually do pay equity. It'll never solve itself. So I think that there's a golden opportunity here to start with some knowledge and at the ground up and build in some other features that will look at closing the gender wage gap and moving our country forward. Thank you.
Well, thank you very, very much. I know it's been a very long evening. I want to thank our witnesses for being here, for providing so much information in a relatively short time. And thank the committee members also for staying later than we had anticipated. So our next meeting will be on Monday at 5:30, and I will adjourn. Thank you so much.